Buenas, my Kunija. Welcome to our studios in Hagutnia. I'm Troy Torres, stuffing my face with chicken, hot dog, rice, and kimchi. I didn't realize we were going live mic that soon. Oh fuck. I just bit my damn mouth. That hurt. I'm sorry about the last few days. I was sick. I had a bad flu. Or it happened so quickly. First, it was like a sore throat. And then the sore throat kept getting worse. And then my legs were jittery, and that's always a sign that like I'm gonna get real sick. And I had fever, and then just like within maybe like an 18-hour period, like a real quick escalation. Oh, and congestion. Anyway, I'm better now, thank God. We during that period, we got to have Johnny live for the first time to do this show, and it was because that was the day of, I believe it was her pre-trial conference or whatever happens before a trial. So just backstory, well, in case you're just joining us. Johnny Rosario, one of our partners here at Kandit, back in February of last year, was arrested in a controversial and contested raid, GPD or Mandania Drug Task Force raid, at condos in Harmon Industrial Park. It wasn't hers. She was actually visiting a friend. And they said that they'd retrieved drugs from the condo, and they said they had been surveilling the place for 3 days, except there was an Airbnb that was reserved the night before the raid happened. So the police were lying about all this stuff. They got drugs from a vehicle of the person who had rented the condo, but who was like the guy who owned the vehicle wasn't even in the condo, like, and it was the drugs were in his car, and so they charged everybody else with these crimes except for that guy. Anyway, long story short, she's been wanting to bring this to trial to prove her innocence. The prosecution offered a plea agreement, so she was charged with possession of methamphetamine, conspiracy, all these different things, right? Just total bullshit. And they finally came forward and said that, okay, fine, we won't charge any of the felonies if she pleads to a misdemeanor of criminal facilitation. So it was plead to a misdemeanor, which is a slap in the wrist, even though she didn't do anything wrong, or go to a trial, which would cost about $2,500 a day on her part. And she was like, fine, get it over with. And so while she was going through that process, before the plea was accepted by the judge, she was on house arrest. So she could only work from 8 a.m. to 5 p.m., Monday to Friday only. And so she could never join me at night for these live casts. So from now on, she will be joining me at night, or she may just be doing the live casts on her own on certain nights, I'm not sure. But we're just really excited to have her back and able to do these shows at night. Yep. Which one? I had to. I need to like cut this tag. Which one? Thanks, Mark Huggin. Okay, I don't have an extensive lineup for tonight, more of an informative sort of thing. Wait, don't go to my screen yet. Oh, before I talk about certain rights that you as a public and those of you who are victims of crimes have, there was a story I was made aware of, not like a big news story or anything, but I mean for this kid, it's a big deal. So we're in a Gay Pride Month. June is Gay Pride Month. It's a celebration of, being as fabulous as we are. And today, I think it was the GW graduation, or was it GW? Whatever graduation was today. There was a kid who graduated top 10, honors and all, worked hard and everything. And earlier today, he decided to come out to his dad. And his dad didn't receive it well and actually refused to go to his graduation. So I just want to say to that kid, congratulations for doing it on your own. And you should be very proud of yourself that despite, the handicap that is your loser ass dad, that you made it that far. And you know what, good for you. It just means that your life is going to be wonderful because of the decisions that you make and not because of the crutch who is your father. And to his dad, go and fuck yourself. I don't know why you have a problem with your own son. And even if, okay, fine, I can see how parents would be shocked or whatever. Maybe they had certain expectations of their children. But to not go to his graduation, he's top 10. Come on, loser. So, anyway, there's a case in the Superior Court system that we are going to follow. And at first I didn't want to because both of the people involved, the so-called defendant and the so-called victim, are people whom I know, friends, And so I just, people were commenting on social media enough, I thought, you know what, maybe this will receive the discernment that it needs through the public eye, because people seem to be interested in the case, that Kandit doesn't need to get involved in this. But I've been looking over I looked at the magistrate's complaint. This is in People of Guam versus Peter Lee Navarro Tainatongo, in criminal case number 0320-19, filed in the Superior Court on June 5th. So just last week, following an arrest, and the charges are family violence with a special allegation of possession or use of a deadly weapon in the commission of a felony, family violence as a third-degree felony, terrorizing as a third-degree felony, and family violence as a misdemeanor. And because, when we were first looking at this, Johnny and I were thinking, we'll move on to another case, right? Well, there might be another case that we can bring and, rip apart or whatever. So I didn't look at the magistrate's complaint. I didn't read it. And then I did today. I'll tell you a little bit more about this tomorrow when we get more information. But after reading this and some other information that we got, I believe there is a bigger story to this, and it speaks to something that may happen to quite a number of people, and it requires looking into if we want justice to prevail. And with that said, because as I was looking at this case, I started to look at the Code of Criminal Procedure, and I found some stuff related and unrelated but I thought that you guys might be very much interested in knowing, especially those of you who have been or will be going through the criminal justice system, and also those of you who are victims of crimes that have been adjudicated or have not yet been adjudicated. Maybe you're in the middle of it. These are really important things to know. So, Why don't we go to my screen now? This is Title 8 of the Guam Code. It's normally called the Code of Criminal Procedure. And we're not going to go through the whole thing or anything. I just wanted to pick out some things that may defy what you would normally consider as urban legend when it comes to criminal proceedings. Blah, blah, blah. Okay, well, let's start with the right of those who are accused of crimes. So one, you have a right to a speedy and public trial. And I've noticed many times that this right is waived by defendants, and oftentimes it's at the recommendation of your lawyer. I want to let you know, just because your lawyer says something doesn't mean it's like the right thing to do. If you don't understand what your lawyer is saying, you got to ask, why would I give up my right to a speedy trial? And like the right to a speedy trial works in your case because that means that you're not giving the prosecution enough time to make up whatever bullshit or find evidence that you don't want them to find or whatever, right? The right to a speedy trial goes to the advantage of the defendant because the defendant has nothing to prove at a trial. It's a prosecution. And the longer of time you give the prosecution to prove something, the better their case is going to be. So it always baffles me whenever I see defense attorneys recommending that you waive your right to a speedy trial. That's something you really should challenge your attorney on if that's the case. To defend in person and with counsel, every defendant accused of a crime who is financially unable to employ counsel shall be entitled to have counsel assigned at public expense to represent him at every stage of the proceedings from his initial appearance before the court through appeal, unless he waives such appointment. Do not waive that appointment. 3, to be informed of the nature and cause of the accusation against him. So this is normally, you first see the accusation in the magistrate's complaint, and then if the arraignment doesn't follow after that, normally you have either an indictment or an information, and information normally comes as after waiving an indictment because you're going to be filing a plea agreement with the prosecutor. What all an indictment is, or an information is a list of the charges, what you're being charged with, what the accusations are against you, and then you enter a plea at your arraignment hearing of not guilty by reason of insanity, guilty, or nolo contendere. So when you do a plea agreement, you are either pleading guilt to certain elements of the crimes. Normally, what you're pleading to when you plead guilt is to lesser charges, and so you'll be punished in some way, but not in. You won't be taking the risk that you're going to face the full breadth of the law and the criminal punishments available to the judges and the juries to give out. But then there's also something called a plea of nolo contendere. It means it does not mean that you're pleading any guilt. All it means is that you are, I believe it's not contesting the charges. You have the right to be exempt from being called to testify and from testifying against yourself. At a trial, like I said, you have no obligation to prove your innocence. The prosecution has the obligation to prove that you're guilty. And so this is the right against incrimination, basically. You don't have to, no one's going to call you to testify. And you sure should not be compelled to testify against yourself. Like if they ask you questions, where the answer which would incriminate you, or have you say in court that, yeah, you committed this crime or that crime, you don't, that's dumb. You have the right to testify, to be allowed to testify on your own behalf. If you fail to testify, you will not be construed, that will not be construed as evidence against you. But if you do testify, you may be cross-examined in the same manner as other witnesses, meaning you open yourself up to a world of shit. You can compel witnesses to testify on your behalf. You can produce witnesses on your behalf and be confronted with the witnesses against you. This is your right. Yeah, this is like your Sixth Amendment right. It says, hearsay evidence may be admitted to the extent that it is otherwise admissible in a criminal action under the law of this territory. I don't know what the law of this territory says about how, this is probably in the rules of evidence, which is in Title 6, I think. I haven't gone through that. But apparently hearsay evidence is somehow admissible. Blah, blah, blah. This is the section, let me turn to that. Okay. Any felony together with any related misdemeanor shall be prosecuted by indictment, or if indictment is waived by the defendant, or preliminary hearing held and an order issued holding the defendant to answer under subsection 45.8 of this code, it may be prosecuted by indictment or by information. Any other offense shall be prosecuted by complaint. So if all you're being charged with is a bunch of misdemeanors, you're just going to have your magistrate's complaint, you're going to be done with it. You go to trial, whatever, do a plea agreement. But if you're charged with a felony, a grand jury needs to come together to issue a bill of particulars and indict you with charges, or if you waive your right to indictment and information will list the charges. And normally, when you're going through that, you're going through a plea agreement process. Okay. No, that's not the one. Blah, blah, blah. Okay, those are boring. But this is one that I wanted to really arrest. Let's see. We're still on my screen, right? So this is the section of the Code of Criminal Procedure where if you've ever been subject to a raid or an arrest or whatever, or if you have been interested in knowing like what would happen if you were ever part of whatever, right? This is the section of the law that governs that. And so you may be surprised about what this says. An arrest is made by an actual restraint of the person or by submission to the custody of the person making the arrest. The person arrested may be subjected to such restraint as is reasonable for his arrest and detention. You don't always have to be arrested, like as in placed in handcuffs. And I didn't know that until I read this. A police officer or a peace officer may make an arrest in obedience to a warrant, or may, without a warrant, arrest a person who, let's see, whenever the officer has reasonable cause to believe that the person to be arrested has committed an offense in the officer's presence. So, without a warrant, a police officer can arrest you if he believes that you just committed a crime right in front of him, or when the person arrested has committed a felony, although not in the officer's presence. Whenever the officer has reasonable cause to believe that the person to be arrested has committed a felony or misdemeanor, whether or not a felony or misdemeanor has in fact been committed. That kind of sounds full of shit, but okay. Or if you are someone who has escaped from any jail or prison or the lawful custody of a peace officer. Well, that makes lots of sense. Now, here's the part that I believe, this is my personal opinion, needs to be struck from the law. It says, there shall be no civil liability on the part of and no cause of action shall arise against a peace officer for false arrest or false imprisonment for an arrest which is lawful under subsection A. This is everything I just read to you. This is subsection A. Really? Like, so they can't get in trouble for, I couldn't take them to the cleaners for being fucked up, making a false arrest. I didn't know this part of Guam Code existed, but I think that needs to be stricken from the record. The senators need to get rid of that shit. Here you can make citizens arrests. A private person may arrest another for an offense committed to it or attempted in his presence, or when the person arrested has committed a felony, although not in his presence. When a felony has been in fact committed and he has reasonable cause for believing the person arrested to have committed it. I had no idea that a private person can arrest another person. Like, how do you do that? Do you carry handcuffs with you? At gunpoint? Like, what? I don't. That's interesting. I had no idea. And this was added by. Let's see, hold on. Normally it says something. I'll come back to that. An arrest may be made day or night. The person making an arrest shall inform the person to be arrested of the intention to arrest him, the offense for which is being arrested, and the authority permitting the person to make the arrest. I bet that doesn't happen all the time. Subsection A shall not apply when the person making the arrest has reasonable cause to believe that the person to be arrested is engaged in the commission of an offense or the immediate flight therefrom until the arrest has been completed. Well, that makes sense. Possession of warrant not required by peace officer if warrant exists. An arrest, an arrest by a peace officer pursuant to a warrant is lawful whether or not the officer has the warrant in his possession at the time of the arrest. However, upon requires of the person arrested, the warrant shall be shown to him as soon as practicable. Is that grammatically correct, Grammar Police on Facebook? However, upon requires of the person arrested. Like upon demand of the person arrested? I don't know. Yeah, well, the police officers didn't follow the law in my case when they arrested me. They refused to give me the warrant. Here, this is common sense. Police officer may use force to prevent escape or overcome resistance. Forced entry to make arrest allowed after notice and refusal. To make an arrest, whether with or without a warrant, a peace officer may break open the door or window of any house in which the person to be arrested is, or in which the officer has reasonable cause for believing him to be, if, after giving notice of his authority and purpose, he is refused admittance. A peace officer who has witnessed the commission of an offense may pursue the offender into any ship, plane, building, or grounds. So, I'm not sure when this law went into effect, but it needs to be updated to reflect Supreme Court decisions that were made just last year, where the Supreme Court over the years actually has been not so quick to violate people's privacy, especially in their homes. There are new Supreme Court rulings on search and seizure of cars and especially of cell phones. So the legislature may want to re-examine this subsection 20.50 and see that it probably does conflict with Supreme Court decisions and that the law needs to be updated on Guam. Otherwise, you're gonna have stinky vigilantes like Chris Champion, you know, gallivanting all over the place making arrests that are not lawful. Station house release formalized and permitted. Notwithstanding subsection 4510, any peace officer may, instead of taking any person arrested without a warrant before a judge, release him from custody. 1, when the officer is satisfied that there are insufficient grounds for requesting a criminal complaint against the person arrested. 2, when the person was arrested for intoxication only and no further proceedings are desirable. Oh, well, maybe that's why, though, they never charged Christine Calvo. Just intoxicated only. When the person was arrested only for being under the influence of a narcotic drug or restricted dangerous drug, and such information or such person is delivered to a facility or hospital for treatment and no further proceedings are desirable. You know, maybe, I don't know if possession of a controlled substance and I thought there was only a possession and then the distribution and all that distinction, but apparently there's another distinction for being under the influence of a narcotic drug. I've never seen that in the charges, though. Pursuant to Chapter 25, any record of arrest of a person released pursuant to paragraphs, blah, 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 blah. This part's boring. There's more to all that. There's like actually a lot more. But then at the bottom of this law, or this Code of Criminal Procedure, is something called the Crime Victims' Rights Act of 2004, and I think it's just so important for people like Jenny David, the mother of Jericho Zahn David, the parents of the 10-year-old girl who was raped by Paul Moffness, Ariane Nepomuceno, who is Paul Moffness's, or one of the survivors from Paul Moffness's first run-in with the judicial system back in the 1990s, and so many others who are either victims of crimes or the survivors of victims of homicide. And of course their family members as well. The legislature back in, where was this? Well, it looks like it's as far back as 1996 through Public Law 21-096, and then updated again through Public Law 27-138. Created a Bill of Rights for crime victims, and this is pretty extensive stuff. Like, and I'm almost certain that the government of Guam, through either the Attorney General's office, the Department of Corrections, or the Parole Services Board, has been violating crime victims' rights for a number of years. So, here's the first one. Victims and surviving immediate family members shall be informed of their right to receive notices and the procedure to receive notices pursuant to this chapter. Victims and or surviving immediate family members shall have the right to request to receive notices provided for under this chapter by filing a request for the Office of the Attorney General at any time. After a request has been filed, the AG shall be responsible for informing other departments or agencies of the government to provide further notices as may be provided in this chapter to the victim and or surviving immediate family members as the case may be. And here are the basic rights. Victims and or surviving family members have the following rights. A, to be immediately informed by the Office of the Attorney General of the final disposition of the case. If the crime charged is a felony, the victim or surviving immediate family member shall have or shall be notified of major developments in the case, whenever appropriate, in order to avoid jeopardizing an investigation. To be notified by the prosecuting attorney if a court proceeding to which they have been subpoenaed will not proceed as scheduled in a timely manner. To receive protection from threats or harm in accordance with local witness and victim protection program guidelines. I've never even seen these program guidelines. To be promptly informed by the victim witness counselor and the probation officer when the defendant has violated a criminal restraining order, a court-imposed stay-away order, terms or condition of release, terms of probation, or terms of a plea agreement. I highly doubt any of that's being done for crime victims right now. To be informed by the police, victim witness, or other criminal justice personnel of financial assistance and other social services available, as a result of being a victim of crime, including information on how to apply for the assistance and services. The court shall provide a waiting area, blah, 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 to have any stolen property or other personal property expeditiously returned by law enforcement agencies when such property is no longer needed for evidence, and the court or the Attorney General has approved its release. To be informed, as provided in this chapter, of escapes and changes planned in the custodial status of the offender that allow or result in the release of the offender into the community. I don't even think they do that well. To be informed by the parole board through the Department of Corrections Parole Services Division when the offender is seeking early release and or parole, and to be afforded a right to submit letters and to appear and testify at a release hearing subject to the provisions of 160.92 herein. In the Paul Moffitt story, I remember that one of the victims from the 1990s she was informed, but the other three victims, she believes, were not informed that the parole board didn't go that extra mile, or just, it's not like they even cared about the letter written by Ariane Pomocino, because they released Paul Moffitt, even though she had, the victim said, no, don't release him, he's going to do it again. This is most likely not happening. To be promptly informed by the Department of Corrections Parole Services Division when the offender has violated that person's parole, subject to the provisions of 160.92 herein. I highly doubt that victims of people who are in jail, who are on pretrial release, have violated their parole, whose case was adjudicated, they're on parole and they violate the parole. These notices are not given to crime victims. In cases charged and pled to as a felony, to be informed by the prosecutor by telephone, fax, or email of all trials, changes of pleas, sentencing, and other major developments at least 3 working days in advance. They're not doing that. To testify as to the actions of the defendant and their effect upon the victim and the victim's family, to be represented by retained counsel, and to call witnesses at sentencing, reduction of sentence, or parole hearing, subject to relevance and at the discretion of the court, to testify at any change of plea or a hearing, to consider acceptance of a plea agreement. While that's something that may be practiced by the Superior Court of Guam, that's certainly something that is not practiced by the Parole Services Board. To be notified by the governor upon submission of requests relative to the pardon of the defendant or the perpetrator, subject to the provisions of blah, blah, blah. Upon written request, witnesses of crime shall be provided the same protections afforded in this section. The right to be treated with fairness and respect for their dignity and privacy throughout the criminal justice process. And sometimes we know that that doesn't happen. Like in the case of the woman who had brought charges against former University of Guam professor Mike Ellert. Those women not only were left in the dark about what was happening, but they were shamed in many ways by government officers. I'm going to the good stuff. Okay, so if you work and you are a victim of crime, this is the right you have with your employer. An employer or the employer's agent who threatens to discharge or discipline, or who discharges, disciplines, or causes to be discharged from employment, or to be disciplined a victim because that victim is subpoenaed or requested by the prosecuting attorney to attend court for the purpose of giving testimony, is guilty of a violation punishable by a fine of not more than $750 and may be punished for contempt of court if applicable. So you could go to jail. If you're an employer who's a dick to your employee because your employee needs some time requested by the prosecutor to either testify or whatever, that the law doesn't tolerate that, then they probably have to They probably have to reform this law or update it because $750 is a slap in the wrist to many of these businesses. During the entire time period where plea agreements are being worked out, crime victims have an absolute right to know what's going on with that. And that's also something that we might not see, and that is not going on. There's more to all of that, but we can do more of those tomorrow. I can't like talk too much because I'm coughing and stuff. So I'm just gonna go straight to wait, come off my screen, Chalu. Go straight to the Guam Sex Offender Registry. We finished Dededo with Johnny the other night, so we're gonna go to by request Mong Mong Totu Maiti. Guam Sex Offender Registry. And I remember when I was looking at this, there weren't too many. It's not like Dededo. Dededo, there were 96. Okay, in Mong Mong, there are 12. Let's start with Scott D. Scott D. Peter Camacho again. He was born in 1971. He's the level 1 offender. He was convicted in 1992 of 1 count of second-degree criminal sexual conduct as a first-degree felony. The victim was 14, a female at the time. He drives a red 1994 Nissan Sentra with license plate GGO 4495. And he lives along the main road in Mong Mong. Let's see. Let's see exactly where he lives. Is this Benson right here? Or is that, no, that's not Benson, right? Which one's Cars Plus? Oh, this one right here. Oh yeah, this is Let My Cafe right here. Okay, so this is Shop for Less here? No, I think this is Benson. No, not Benson. The one that's gonna be Payless, is that? Yeah. Right?
I think that's further to the right. Yeah, you're right. That's Benson, and the one that's going to be Payless, you're right.
I'm confused. Well, this is Cars Plus, right here,
Yeah.
with all the cars. Of course, that's Cars Plus. So if you go in that road, you go all the way down to Roy Damian Street, you hang a left. He lives in this 4th house right here. Juan Francisco Borja was born in 1956. He's a level 3 offender. He was convicted in 2015 of 4th-degree criminal sexual conduct as a misdemeanor. So it's a low charge. He doesn't have a car and is currently unemployed. And he also lives on Roy Damian Street. Oh, is that Chamorro Gardens? Let's see. Where's this? That's Chamorro Gardens, huh? Yeah. He lives in a unit in Chamorro Gardens. Unit number B-107. Albert Blas Camacho was born in 1949. He has a different colored eye, doesn't he? Anyway, he's a level 1 offender. Convicted in 1991 and again in 2009. In 1991, 1 count of first-degree criminal sexual conduct as a first-degree felony. And then in 2009, on 2 counts of second-degree criminal sexual conduct as a first-degree felony. His victims were all female, ages 7, 12, and 12. He has 2 cars. One is a 1992 red Toyota 4Runner, license plate Mongmong 5252, and a beige, excuse me, a beige 1996 Corolla Toyota sedan, license plate AG 8328, and he lives on 114 J.A. Camacho Street. Let's see where that's at. Where's the red dot? Do you see the red dot?
Says no results found.
Oh, no results found?
Yeah, they got the sergeant waiting.
Oh shit, okay. Whoops. Oh wait, no, it's this one I need to take out. Hold on. Sorry, I fucked that up. Sorry. Okay. Okay. He lives. That used to be Graphics Center here, right?
Yeah.
Okay, so this is Shop for Less. This area, this thing right here, and this is Canon Copier or whatever, right? The old Sayer building, yes, Sayre. And you just go down this road a little bit, take the first right, and he lives in these apartments here. Oh yeah, you're right. Those are Titan apartments. I think I went there once for a deal. Further down the street. Tomas Julian Camacho III, born in 1993. Oh, a happy belated birthday, Tomas. He was a level 3 offender, convicted in 2016 on 1 count of 4th-degree criminal sexual conduct against a 17-year-old female. No car on record, is employed at Harmon Loop Road. And he lives in Duende Street, Sika Apartments, number 3. Let's see what this is. No results found. Well, if you know where Sika Apartments is, that's where he lives. In unit number 3.
Yeah, the one street is right off of going to Haven Street.
On the Aganias, more the Agania side or more the...
It's right after the old sub at the power station.
Oh, so that's close to the, very close to the Agania side. Okay, so Cello Eric says that Duende Street is just sort of in the vicinity of the Mongmong Church. Or is that the Mighty Church? What is that called? The MTM Church? What's the name of it? It's one of those like Nuestra Senora things, right? Malcolm Vernon Cruz, born in 1981, is a level 3 offender. He's fat. Convicted in 2003 on 1 count of 2nd-degree criminal sexual conduct as a 1st-degree felony, and 1 count of 3rd-degree CSC as a 2nd-degree felony. His victims were both male, ages 12 and 13 at the time. He drives a, okay, like, I swear to God, I'm not trying to be a dick, but like when I saw his face, I kind of knew that his victims were male. Just, you know, judging a book by its cover. So he drives a blue 2002 Mitsubishi Montero, license plate Dededo 3261, and he lives on 157A Tuba Street. whenever I yawn, my ear pops because I think I have an ear infection, and like it feels better. I've never had an ear infection before, so I'm just getting old. Oh, this dude lives like in like the outskirts of the Ville. So it's in one of these, well, no, not necessarily the outskirts. The outskirts are over here. But he lives deep in. Is this the pipeline? No, or no, the pipeline is over here. So before the pipeline, you take this road, it goes into, I guess, where there are large apartment buildings here. That's where he lives. Pascual Kazuma De Leon Guerrero, born in 1985, is a level 1 offender. He's definitely fat. Convicted in 2008 on 1 count of sexual abuse of a minor in the 3rd degree. His victim was an 11-year-old female. No car, no job. He lives at 248 Biang Street, number 2B. Oh shit, this hurts. All this place is like littered with sex offenders. So he lives behind the old graphic center building. It doesn't look like there's a house there, so it's probably like one of those surrounding houses. Maybe it's this one here. I don't know. Oh, okay. How can you tell? Oh, okay. Okay, okay. Melvin David Diaz. I'll make this guy the last one for tonight because I'm fading fast. He's on probation right now. He's a level 3 offender, born in 1981. Oh shit. I wonder why he looks so old. 1961. It doesn't say there are any. This must be like a not really updated profile. According to this, there's no offense. That doesn't make sense. He lives at 268 B Vincent Lane. Oh, he lives on that same road. Oh, there's a lot of sex offenders in this area. And there, the red dot shows it. Okay, so we'll go through the rest of that tomorrow when Johnny's here. Because I like how colorful she is with these people. You know, like, so we are not about judging people who commit crimes. Matter of fact, a lot of what we do is to advocate for them when their rights are being violated. But we have a rule here in Kandit where we don't like sex offenders and child abusers and wife beaters. On that note, we also have a rule that if we find out that you are not a victim at all, that all you did was file a false complaint and drag someone through the mud of the legal system and against their reputation and credibility, we'll call that out too. Johnny, I like class a couple nights ago how you're making fun of everything about these guys, from like the Keaton one The one she said is from Cross Island Road. No, I just talked about fat people. I'll keep that. I needed to take my Robitussin and go to sleep. All right. Good night, everyone.